David, can you enable my video? Hello, this is Nate Persley. I am double rolling today and thrilled that we're joined by both Daphne Keller and Jamal Green. Daphne heads our program here on platform regulation, and Jamal Green is the Dwight Professor of Law at Columbia and my former colleague there, as well as being one of the chairs of the Facebook Oversight Board. He's a scholar of freedom of expression, constitutional law, comparative constitutional law, and many other things. I am unfortunately testifying before the Maryland state legislature right now simultaneously, but that's a virtue of being in this Zoom environment, that you can be in two places at once. So I will be coming in and out, and Daphne has been kind enough to step in. So thanks very much, Daphne, and I'll see you guys later.
Thank you, Nate. So we are very fortunate to have with us today Jamal Green. Nate gave a very brief intro, but I'm going to expand a little bit. Jamal is the Dwight Professor of Law at Columbia Law School, as Nate says. He teaches courses in constitutional law, comparative constitutional law, and the law of the political process. He's the author of a great recent book, How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart, as well as numerous articles and book chapters on constitutional law and theory. And as Nate mentioned, Jamal is also the co-chair of Facebook's Oversight Board, an independent body established by Facebook to review content moderation decisions on Facebook and Instagram. He served as a law clerk to the Honorable Guido Calabresi on the U.S. Court of Appeals for the Second Circuit and for the Honorable John Paul Stevens on the U.S. Supreme Court, and earned his JD from Yale Law School and his AB from Harvard College. I want to remind the audience before Jamal starts in that you can submit your questions through the Q&A function. And at about the half-hour mark, we will switch over to Q&A and refer to those questions. And I'll ask Jamal questions and repeat your questions. So Jamal, please go ahead and take it away.
Thank you, Daphne. Thank you, Nate. It's really a pleasure to be in this room and to be hosted by this group. It's also, I would say, a little bit intimidating because I think notwithstanding my work on the Oversight Board, I still consider myself to be something of an outsider to the law and technology community. And in speaking of the Oversight Board, I should say before I get into the substance of what I want to talk about, that nothing I say today speaks for the Oversight Board. It's all purely me in my wearing my purely academic hat. I want to use the opportunity to marry a couple of different perspectives that I've developed over the last several years on rights and on social media. As Daphne mentioned, last year I published a book called How Rights Went Wrong. The basic argument of the book is that lawyers and citizens in the US tend to approach rights conflicts in ways that essentialize rights, ways that understand rights in presumptively absolute terms, and that in part for these reasons, they also tend to judicialize rights rather than adjusting judicial review to the nature and the complexity of modern rights. We tend to adjust the scope and substance of rights to the limits of traditional judicial review. I wrote in the book that these tendencies tend to distort our understandings of justice, that they deny our political discourse a lot of the resources that they need to sort out complex rights disputes, and that they tend to exacerbate political polarization in a variety of ways. It's an issue I continue to find interesting and indeed very current. But as we've talked about, I also happen to wear a very different non-academic hat as co-chair of the Oversight Board. It's an institution that is familiar to many of the people on this webinar, but for those who don't know, it is a body that independently reviews content moderation decisions made by Meta, the company formerly known as Facebook, and the board issues binding decisions on individual pieces of content. and also issues policy recommendations that extend beyond the individual case. As I said, I want to marry some of the observations about rights that I make in the book with some of the work of the board, although again, I'm not speaking for the board itself. I'm going to do that from an unusual perspective, namely a perspective that is, for my purposes, hypothetical. And what I want to do is I want to draw a subtle distinction that, to my mind, turns out to be an important distinction in how we frame the regulation of content on social media. It's common in the thought circles in which I now find myself to think about how the law would treat platforms if they were state actors, right? So, for example, as many of you know, Florida and Texas have passed laws that impose duties of consistency and duties of viewpoint neutrality on content moderation. And much of the response from the US legal community has been to say, these laws would make sense. And in fact, they would mirror a lot of constitutional constraints, but for the fact that, of course, social media companies are private actors. We frequently see claims, in other words, that social media sites restrict content in ways that would be illegal for the government to do. At times, there have been analogous claims from international human rights lawyers about the ways in which content restrictions on social media sites are inconsistent with protections given to free expression under important international treaties, most significantly the International Covenant on Civil and Political Rights. Now, I want to resist some of these conclusions, or at least the most simple-minded versions of those conclusions. And to motivate my thinking about this, I want to reframe the question from asking what regulations would be permissible if social media companies were governments, and instead ask what regulation would be permissible if governments were to run competitive social media platforms. Now, I've just made a distinction that's very subtle, as I've noted. In fact, the two questions I've posed, what would happen if we treated social media companies as governments versus what would we do if governments ran social media platforms? They're the same question, formally speaking. But I think the frame does matter. And the frame matters, I think, because the shift in frame focuses or forces us to start with the question of why the government would do such a thing, rather than starting the question with the rights of users. So instead of casually analogizing the rights of platform users to the rights at stake when governments paradigmatically act against individuals, I find it useful to see what follows if we start the inquiry by thinking about the purposes and distinctive structure of social media platforms. The shift in frame, I think, or at least that's what I'm going to argue, forces us to think not just of when individual rights trump government action, but to also keep in mind what the state is trying to accomplish, or by analogy to a private institution, what the private institution is trying to accomplish when it regulates speech in a particular setting. And so I hope, leads us to think about rights conflicts, not just in terms of what pathologies are committed, but also in terms of what effective governance actually requires. So to return to the hypothetical, right? If a government were to set up a social media platform, it would be engaged in an activity that is not paradigmatic of the government activity that motivates the First Amendment or that motivates the international human rights regime. And the question is, how much does that difference matter? That's the essential question. Now, I should say that although my focus is not on any existing actual platform, the question is not just a thought experiment, right? Facebook/Meta, other social media companies have committed themselves to being guided by the UN Guiding Principles on Business and Human Rights. And the Oversight Board is charged with reconciling that commitment with Facebook/Meta's content practices. It's conceivable that other platforms may at some point pursue analogous projects in self-governance. As many of you know, Twitter has repeatedly been in the middle of lawsuits over the behavior, or the platform has been involved, I should say, in lawsuits over the behavior of politicians on the platform, and how they're permitted to interact with other Twitter users. There are proposals from people like Ethan Zuckerman at MIT to build out what he calls digital public infrastructure. Even if proposals of that sort don't involve the government largesse, they will require the building out of principles of public law to govern the social media space. Now, in the interest of time, because I want to get to your questions, I'm not going to linger as long as I could in the weeds of how to answer this question under the domestic constitutional law of the United States. I think there's a lot that one could say about how U.S. First Amendment law would treat a government setting up a social media platform, but I'll make a few general observations. Because First Amendment law is both very demanding and also very old, there is a mature network of frameworks for thinking about free expression in the context of government institutions that are providing forums for speech rather than regulating and punishing the primary conduct of individuals. I'll mention two of those frameworks. There are more than two, really, but I'll mention two of those frameworks just to illustrate a lingering problem in how US lawyers tend to think about these issues. The first framework is public forum doctrine, right? So public forum doctrine arises out of a recognition that there are forms of government property that are opened up for free expression, often selectively, and that distinctive rules are required under those circumstances. So for example, if the government runs a town hall meeting or allows certain forms of expression on a military base, what kinds of discrimination between speakers or between different forms of speech content are permissible? And generally speaking, the formal answer that courts have come to is that viewpoint discrimination is never permitted under these circumstances. And content discrimination is sometimes permitted, right? It's permitted if the forum ex ante in advance has been limited to particular topics. Content discrimination is allowed, but it can't happen extemporaneously on the fly. One of the key cases in this line of decisions involved a public auditorium in Chattanooga, Tennessee, that could be leased out for private events. It's a municipal auditorium, but a private theater group wants to put on a production of the musical Hair, which has nudity and has some sexual themes. The city denies their application. The case is technically about the permissibility of prior restraints, but the Supreme Court, in essence, says that this kind of content discrimination was not permitted unless it could be shown that the content was not just racy or subversive, but it was in fact obscene. And as many of you know, the standard for obscenity is a very high one, generally requiring highly graphic pornography that has no purpose beyond sexual gratification. Now, that would be a very demanding standard for a public social media platform. But there's another framework that we might think is relevant, right? In 2015, the US Supreme Court decided a case involving a Texas Department of Motor Vehicles program in which car owners could suggest logos and phrases to place on their license plates. And there are a bunch of applications, a very wide range of applications are readily approved. Rather be golfing, a Jeff Gordon, a NASCAR driver related license plate, a plate for the Oklahoma Sooners, the rivals of the University of Texas. But then, of course, because this is like out of a law school hypothetical, the Sons of Confederate Veterans show up. They apply for their own license plates, which include a depiction of the Confederate flag. And the Texas Motor Vehicle Department rejects the application. Sons of Confederate Veterans files a claim for violation of their First Amendment rights, gets to the Supreme Court. Now, if Texas had made its license plates into a public forum of some kind, like the Chattanooga movie theater, it would have lost the case because it was plainly engaged in viewpoint discrimination. But Texas wins the case. And the way it wins the case is that instead of saying that it's a public forum, the Supreme Court says that Texas was engaged in government speech, that it was in fact speaking for the state of Texas, even though they were inviting private citizens to volunteer their own logos and expressions. Government speech doctrine comes from the fact that because the government has to have the freedom to express its own viewpoint, there aren't very many limits, very many constitutional limits on what the government can say, ways in which it can engage and discriminate in favor of certain viewpoints, but not others. And so this means that in theory, Texas could screen its license plates however it wanted to. Now, this is an odd kind of discontinuity, right? Because taken together, this line of cases suggests that if the government forum is a so-called public forum, there are very, very severe limits on how the government can restrict speech. No viewpoint discrimination, content discrimination only under limited circumstances. But if the government forum is government speech, then there are almost no limits. In fact, the court has never articulated any limits on government speech and how it may be restricted in the context, in this context. And so what that means is that even though the question of whether a forum is a public forum or is instead an instance of government speech is a very subtle, very sensitive inquiry, the consequence of calling it one or the other is massive and in fact discontinuous. It goes from one end of the First Amendment spectrum, allow everything, to the other end, which is allow very little, right? So that's where we find ourselves, right? And it's, in fact, I think this discontinuity that leads the court in the Texas case to this very curious conclusion that Texas itself was speaking through its citizens' choice of license plate because they knew what the consequences of calling this a public forum would be. Now, I'm going to return in a moment for what that means for the status of a hypothetical public social media platform. But in the meantime, let's consider international human rights law. What does that regime have to say about what would it have to say about speech on a public platform? The answer, so far as I can tell, is very little, or at least very little with any clarity. The International Covenant on Civil and Political Rights and the authoritative statements that have been made about it by the UN Human Rights Committee is where one would most naturally look for guidance on government speech restrictions. Article 19 of the ICCPR allows for certain speech restrictions when, among other things, necessity and proportionality are satisfied. And in theory, application of proportionality analysis should enable the international human rights regime to avoid at least some of the perplexing discontinuities we see between public forum and government speech doctrine in US First Amendment law. Proportionality has a certain degree of flexibility to it that we don't see in the more categorical US First Amendment. But there are at least two, I think more than two, but at least two significant differences between platform governance and the kinds of conflicts that have historically generated human rights responses under the ICCPR. First is the fact that content moderation, with content moderation, we're usually talking about removal of particular pieces of content being the significant penalty, right? This is very different from being detained, from being fined, from being tortured, from being subject to other coercive remedies. Proportionality analysis should, at least in some ideal form, account for the difference between a very light sanction, which is your speech doesn't appear on the platform, versus a very heavy sanction, such as you're being arrested, detained, imprisoned, and so forth. The second significant difference is the scale of content governance on the internet. The scale enables just ordinary speech harms in the ordinary government regulation context to spread in ways that historically have not been possible. Again, this should be relevant to proportionality analysis, but the relative immaturity, and I don't mean that in a pejorative sense, just the lack of cases within the international human rights jurisprudence as applied to government-provided platforms, means that there's not a lot of existing guidance, or at least authoritative guidance, on how proportionality should apply in this very unusual, historically unusual context. Now, when we move from the hypothetical public platform context back to the real world context of private platforms, the problem of translating from international human rights norms into norms that can actually be applied becomes even more complicated. And this is because private platforms, in addition to being at scale, in addition to having a different kind of remedial context or penalty context, they also have their own set of expressive interests, right? Parler's interest or Twitter's early interest in allowing more expression than Facebook is not just a pure financial interest. It also has, it's an interest that has expressive content, right? And any regulatory regime needs to account for that expressive content. A version of this expressive interest, I think, is what shows up in public forum and government speech doctrine under U.S. First Amendment law. Right, the law recognizes that the platform operator has a right to express itself through the content limits it places on the platform. In the US, because we have these really kind of dichotomous, binary categorical instincts under US First Amendment law, it means that the decision maker has to choose between the expressive interests of the user, and this is where public forum doctrine generally lands, versus the expressive interests of the host. That's where government speech doctrine generally lands. We sort of choose one or the other rather than integrate the observations, integrate the speech values that are on both sides into a single regime. Now, in my view, these cross-cutting legal norms, the expressive interests of the user, the expressive interests of the platform, make it basically unintelligible to measure platform rules, the rules that are on the platform, by the quantity of speech that they allow. Right? It's just that when we see a certain level of speech, we don't know how much weight to give to the expressive interests of the platform versus the expressive interests of the user. I think it's better to measure platform rules, or at least it's easier to perform the kind of translation we're talking about between legal norms within different kinds of regimes. If we measure those rules not by quantity of speech that they allow, but measuring them by their consistency, measuring them by their transparency, measuring them by their susceptibility to abusive or arbitrary application. I want to make a broader point before I wrap up, which is this. I've tried to show that the question of applying legal norms to content moderation on social media platforms can't coherently be reduced to a simple act of translating government regulation of primary conduct to private regulation of platform behavior. There's a larger point to be made here, and this is where this is a point that I make in my book, How Rights Went Wrong, which is a point about flattening conflicts over rights into applications of the most paradigmatic or pathological possible violations of those rights. There's a well-known article by my brilliant colleague, Vince Blasi, about the pathological perspective in free speech law. And the point that he was making, this article is several decades old now, the point that he was making is that we should understand free expression norms from the perspective of the most pathological possible environment. So we should craft them out of fear of what could happen if they were in the most dangerous hands, or if the country were in the grips of some kind of authoritarian regime. I think that perspective is highly problematic in the context of platform regulation. And I think it's important to think carefully about the fact that there are other kinds of pathologies that can result from not allowing effective governance of certain kinds of institutions. In the speech context, if we see all speech restrictions of any kind as analogous, even in a mitigated way, as analogous to criminal sedition prosecutions or analogous to purges of one's political enemies, we're going to misunderstand or mistrust the very significant governance aims associated with most speech restrictions. We have to, I think, instead understand rights conflicts when we see them as the ordinary byproducts of committing ourselves to a genuinely pluralistic social and political life. Right? Rights conflicts do not arise because some of us are pathological, evil, authoritarian, and others of us are not. Rights conflicts arise because we are different people from each other. We have different values, different commitments, speak different languages. There are different things that are important to us. And so there's naturally going to be a conflict in any such society. We should instead of seeing those conflicts as a chance to scold somebody, to see those conflicts as invitations to creative forms of collective governance And that's what the book is aimed towards, and that's what this paper is aimed towards as well. And I will pause there.
Thank you so much, Jamal. That was very interesting, and the paper's super interesting. I urge anyone who hasn't in the audience to take a look at it. So I think I want to start by pushing a little bit more on a question that you started with at the beginning of the presentation, which is why the state would operate a platform. And I don't mean to fight the hypo, because I think the hypo is useful for the reasons that you identify in the paper. Rather, I think that asking why the state is acting at all is relevant in the case law. And I'm going to rattle off some examples. Don't feel like you have to speak to all of them, but hopefully, some of them will be useful as entry points. So I think looking at the purpose of the government undertaking helps us to think about the differences between Walker, which is the license plate Sons of the Confederacy case you mentioned, and a more recent case, Mattal v. Tam. In the license plate case, it's really what the state is doing is trying to maintain auto safety with its licensing regime. And the speech on the license plates is kind of incidental. And the court said you don't have to turn those license plates into forums for free speech for everybody. In Mattal v. Tam, by contrast, the court said that the federal government can't deny trademark registration for offensive terms, that one is a First Amendment restriction. And that seems like kind of a reasonable outcome to me, because with trademark, the state is quite literally, controlling access to the marketplace of ideas, or at least of symbols. Like, it's undertaking this thing that's really different than a car licensing regime. So the reason that it operates the system seems relevant. Similarly, in the ALA cases about where the court said that it was okay to require libraries that receive federal funding to put porn filters on internet access there, the court accepted that it's part of a legitimate function of libraries to include and exclude some information. I would think there's similar thinking behind other kinds of sort of state provision of public goods, or goods that the market wouldn't generate, like choosing public university classes, academic hiring, Smithsonian Museum exhibits. The state is undertaking to do this useful thing that the market wouldn't have provided. So coming back to platforms and the idea that that the state might build a platform, and we want to know, even hypothetically, what the rules could be under the First Amendment on that platform. Why is the state building the platform, and do you think that shapes what the First Amendment rules would be?
Great. So I think this is a great question. I think I'll start by saying that I agree with. I think all the examples you gave are show that, in fact, that if push were to come to shove, I think a lot of our instincts as sort of reasonable people in society, understanding the complexity of different kinds of institutions, would more or less get to the right place in a lot of cases, right? I agree with the outcome in Walker. I don't agree that it's government speech, right? So that's the problem here, right? Is that the court comes to what is essentially a common sense answer, and common sense. All you need to know, right, is would they have to allow a swastika or a fetal remains or something on the license plate? And it seems sort of insane that you'd say that the state has to allow that. But it also seems insane that you would say that the state could allow the Democratic Party but not the Republican Party to advertise on license plates. But that would follow, right, from what the court says about it being government speech, right? So we end up with a category that actually doesn't fit a lot of our instincts very well, and it's just a mismatch between the fact that you should have a certain degree of flexibility given the kind of thing we're talking about, license plates. Just as, and you named, people picking courses in schools, and I mentioned in the paper, like, hiring faculty, right, or admitting students to a university, or you can name any number of ways in which we, in fact, allow lots of institutions to discriminate on the basis of speech. And if you actually were to litigate this, you would actually struggle, I think, a little bit to figure out exactly which of the existing doctrinal boxes to put it in. The American Library case, I think, is a good example of that, where the court is just kind of like, well, look, these are libraries. And we know, and I think it's a Rehnquist opinion, where he does the Rehnquist thing, where he says, look, it's a library, and that's different. And that's the analysis, right? So, but the rest of First Amendment doctrine doesn't proceed this way. Part of what I'm trying to suggest is that there's a continuity between the fact that we actually tend to kind of adjust doctrine to the kind of institution we're talking about, and then, like, if we were in this platform context, we would end up doing the same thing, which is to say, we would end up saying, well, this is would we really say if the government sets up a platform that they have to allow pornography? Like, no, of course we wouldn't say that. And then we would struggle to figure out what the right box is. And so what I'm trying to suggest is that in fact, it's too quick, right, to just say that, if the government were doing this, obviously they couldn't engage in content moderation. That seems wrong to me. I don't have the right doctrinal language for saying it, but I do share the same set of instincts, and I can give you lots of examples where sort of any person exercising their common sense would say that that even if we can't find quite the right doctrinal category, the case has to come out a certain way. Now, why would they be doing this? I don't know. You could imagine a hypothetical situation in which the government wants to set up a platform that is not advertiser driven, right? So, like, if the government it thinks that there's an engagement problem and an amplification problem because of all the because of the need for eyeballs and so forth, and they want some kind of competing platform that is it sets up some foundation to just do its own content moderation, or sets up some entity to do the content moderation in ways that are driven towards public purposes or something. I'm sure there'd be lots of controversy about setting up that kind of institution, but if it did, it seems to me that the question of what kind of content moderation it could engage in would not. I think there are good reasons to think that it wouldn't follow designated public forum doctrine, right? Even though I think that's probably where it would fit most seamlessly. I think, notwithstanding that, if the government said, "Oh, by the way, you can't use racist insults on this platform," that there'd be good reason for First Amendment doctrine to allow that to exist. And so, whatever other purpose the government might have, that purpose is going to be really important to figuring out what kinds of rules are permitted. And that's the point. It's that you don't just start from, oh, they're violating speech and therefore strict scrutiny applies, right? Unless it's some very strange reason why it doesn't apply. You start from the kind of institution it is, and the purpose for which the institution has been created.
That makes sense. I saw Nate briefly pop in. Possibly Nate was wanting to ask a question.
I just got finished testifying in Maryland. I don't want to violate the cardinal rule of coming into a seminar and just asking a question. So I will wait till you've exhausted some of the other questions that you might have.
Great. Well, okay, so here's another question. I really appreciated your focus on due process and the idea that maybe what can be most important about content moderation on a private platform or a hypothetical public platform is the process. Realistically, of course, even the best case scenario of the fair process that platforms are going to provide with, notice of rules and appeals and transparency and so forth is going to be quite a weak emulation of what, civil procedure or criminal procedure would provide. And I'm curious, as you think about the hypothetical government platform, do you think that it too gets to provide the sort of dilute due process that platforms do because it's operating at scale, because it's subject to the same realistic constraints that platforms are, or do the due process obligations that come with plaintiff challenging a government restriction on speech carry over to the government-operated platform?
So what I would say is, and I'll say first, since I'm seeing in the Q&A that people don't have access to the paper, and I will just say, to the extent, I don't know if the Cyber Policy Center ever posts these papers, but if they want to, you have my permission to do so. I don't think I've put it on SSRN or anything, but I could probably do that for those who are looking for it. The due process point, one of the key points that I make in the paper that I didn't emphasize that much in the talk is that it's very difficult. While it's very difficult to judge platforms based on just sort of naked speech norms, because they're cross-cutting in lots of ways, that there might be some room for due process norms to apply. And Daphne's asking, are these different? Should these be different for private entities versus public entities, given the scale issues and so forth? And one thing I would say is that and part of the reason I make the due process, one of the points I try to make about due process in the paper is that some of our due process instincts should be different when we're talking about this kind of scale than if we're not. So I talk a little bit about prior restraints, for example, which are considered the sort of cardinal sin in free speech doctrine. The last thing the government should do is have a prior restraint. You should wait for the thing to happen and then punish after the fact if you're allowed to punish after the fact. Never prevent the speech from coming out in advance. And it seems to me that if one is focused at least as much on fair process as one is on the quantity of speech itself, that there might be actually some good reasons for prior restraints, and prior restraint because prior restraints can be evaluated in advance of the speech actually happening, right? So you can actually spend a lot of time thinking about what the rules should be and less time thinking about the individual application of the rule in a specific case. When you're talking about internet scale, the specific cases you're going to have lots of mistakes in specific cases, just because it's just impossible not to. But you can talk about whether the rules make sense or not, whether the rules are fair, whether they're generated in a fair way, whether they're likely to lead to lots of mistakes or not, what the balance between likely false positives and false negatives are. We can ask those kinds of questions, and indeed, crafting legal norms in this space that we know in advance are going to lead to errors. So more rule-like norms rather than standard-like norms actually have some advantage because those norms can be evaluated in advance, right? So there's this interesting kind of trade-off where the due process values being important changes our instincts about some free speech norms. To the question of should they be different for the government than a private actor, my instinct is yes, but in both cases, we're talking about the same kind of problem in both spaces, which is a basic problem of fairness. And in both instances, you're going to be constrained by scale. So there are material constraints on resource constraints in robust due process, either for a private platform or a public platform. And we have to, that's just a reality that can't be avoided. And so I think in practice, you end up with the same sort of normative concern and the same kind of constraint.
I think that Nate does have a question.
Thank you. Yeah, I feel now comfortable enough to vault into the fray here.
You were comfortable before. You knew that.
Yeah, I'm no shrinking violet over here. So let's start. First of all, I think this is fantastic. The way you are posing the question, I think it's totally original. I think it's really important to think about it this way. Because those of us who you start off the piece in the right way, which is to think about, well, look, everybody is saying that this is everything turns on whether they're a private actor or not. But I do like the idea of thinking about what would happen if you had a public social media company or presence or whatever. I want to talk about two things. The first is I totally agree with that your point about scale and the like. And Evelyn Dueck has a great piece coming out, I think, in Columbia Law Review on making a point like that. But I want to just press you on how algorithms should be, if algorithms were written into law, right, for this public social media platform? How would they be evaluated? So for example, I actually don't even know, saying algorithms writ large. Suppose you have 100 words or whatever that racial epithets that are prescribed as you may not say these on the platform. Is your view, and now of course we know that that's all going to, if that were passed as law for the public square, that would be unconstitutional. Is it your view that that would be okay as a kind of filter that would be put on this public social media site?
So I like this example, and I'll say before a bunch of listeners have a conniption, that I'm not making a prediction about what the Supreme Court would do in response to this kind of scenario. The Supreme Court would do lots of things across a lot of areas that are not consistent with my instincts about how the Constitution should be rightly interpreted. What I'm suggesting is that there are some good reasons to think about that situation. So the platform says here are 100 slurs, and these are not going to be allowed. And if you're put up, you're not, we're not going to arrest you. We'll just use a bot to like remove them from the platform. What I'll say is a couple of things. So one is, I think there's good reason to think that shouldn't be unconstitutional necessarily, depending on whether, if there's a partisan bias or something like that, or maybe one could show ways in which the list is inconsistent, or maybe it's overbroad and would capture lots of things that we think are legitimate public discourse. But the bare fact that the state is policing what is in effect a hate speech norm, which in the realm of primary conduct, we think, First Amendment allows you to engage in hate speech. The fact that you're policing a hate speech norm on a platform seems to me that there are lots of reasons not to think that should be unconstitutional. And then what's the way in which you enforce that norm? That gets back to the due process point, which is to say, if the way you enforce that norm is by saying, we think hate speech is unconstitutional, we think hate speech is not allowed on the platform, and in any individual instance, we're not going to have a list, right? In any individual instance, we're going to evaluate whether this is hate speech or not. I think that's more problematic because can lead to all kinds of arbitrary, politically motivated, ideological application. Then if you say, look, we're not going to think about this as a standard that gets adjudicated piecemeal by piece by piece by piece. We're just going to say, because we have to do this at scale, here's the list. And we can argue about the list. We can argue about whether the list is fair, et cetera. But the list is the list. And that's how we're going to police it. I think that's less problematic insofar as it's easier to police, right? So you have fewer due process concerns.
The thing I don't understand though is that generally speaking, like prohibiting certain words would be, a pretty big, hot third rail of First Amendment law. And so don't you still, need to go through the kind of state interest calculus here as to whether whether you're going to allow at this level of filtering a different rule to apply than you would if it was banning conversation in the public square, right? So you have to say, oh, well, we're a social media platform. We don't want to allow this kind of speech because we think that it's going to harm people's feelings, right, and the like. That seems to be the kind of thing which is inconsistent with, pick your RAV or the Virginia cross-burning case and the like. So what is the hook? I understand you're not saying the Supreme Court would go in the same direction you are, but what would be the hook there as to how you're going to say, all right, in this particular realm, we as the government can issue a set of prohibited words that we can't in the public square?
Well, there are existing cases, Pacifica, for example, that allowed for that to happen. Now, of course, that's criticized in lots of ways, but that case has not been overruled, and it is understood in the context of media regulation, where that as being fundamentally different than the public square. Now, of course, there are specific reasons cited in those cases that don't apply to the internet, and that the courts have said don't apply to the internet, right? But the point simply is that it's not foreign to free speech law, right? To say that that some spaces are different. And I'll just go back to government speech again, right? Where Walker versus Sons of Confederate Veterans is such a case, as well, outside of the media context. And so the question becomes, well, what are the real reasons? And we could come up with lots of examples that are not in the case law. We're both on faculties, right? If we were to go to a public university, and they said, the reason we're not going to hire you is because we don't like your speech, or it's filled with racial slurs. That's not unconstitutional to say that, because we think that there are certain kinds of institutions that get to make certain kinds of decisions in the interests of the institution. Now, if the institution in this case is, we want a platform that's accessible to people, right? And so if we were to apply First Amendment norms to this platform, it would mean that it's filled with smut and porn and spam, and then people wouldn't use it. Well, then you're undermining the purposes of the institution, right? So that's the analogy. Again, I'm not suggesting that Neil Gorsuch is going to accept that. Right.
Can I ask one last one, Daphne, before you go to others, which is, let's talk about disinformation and what you think you could do. What could a publicly controlled platform do with respect to policing disinformation that they can't do in the public realm? Do you think that there would be greater capacity to ban, whether it's COVID disinformation or QAnon stuff or election fraud claims and the like, that the capacity of the government to decide what is truth on its social media platform is expanded, or is that an area that might be more fraud?
I do think it's more fraud. And what I say in the paper is that, the kinds of questions we have to ask are not just like, is this viewpoint discrimination or is this content discrimination? The kinds of questions that we'd want to ask are, what's the possibility that this is susceptible to abuses of various kinds? Is this capable of consistent application and so forth? And in the paper, I talk about nudity and sexual content. I talk about hate speech, and I talk about misinformation on a kind of spectrum where with nudity, there are lots of borderline cases, lots of controversy, right? But we have less reason to be suspicious if the government just sort of has a rule, and it's also easy to create a rule if the government has a nudity rule, as opposed to misinformation where it's not very susceptible to a rule. And you get lots and lots of borderline cases, you get lots of politically fraught, politically motivated cases, and there'd be lots of reasons not to trust that the government is doing this, policing this in a way that we can trust. So I do think that that's a situation where the free speech norms are much closer on platform as they would be off platform.
I certainly have more, but Daphne, why don't you jump back in?
Sure. So I'm going to move to some questions from the audience. So Frane Morevic asks, when looking at content moderation decisions under the German NetzDG and cases in the Lumen database, it seems like a lot of them are taken on the basis of companies' terms of service rather than illegality. Doesn't this blur the line between legal restrictions with all of the due process and human rights protections and speech protections and so forth versus TOS restrictions?
I guess I'm going to reframe the question a little bit by saying that the terms in which the paper is written, assume that we're talking about a government platform, and so the kinds of protections that attach to those are going to be, whether you call them terms of service or call them laws, are going to be constitutional in some sense. I do think that the kinds of constitutional restrictions, or the way in which we understand those constitutional restrictions, should be, but aren't really under current doctrine, but should be attentive to what the remedy is, right? So if the remedy is someone might be subject to criminal liability, that's a very different remedy than in fact they're not punished at all, but just their speech doesn't appear on the platform. Now, going back into the private context, yes, I don't actually know this to be true empirically, but I assume it's true empirically. It sounds true empirically that most removals are because of terms of service violations and not because of illegality. But in the private context, I don't think that human rights protections or due process protections doctrinally apply, at least not in the US. Germany, I'm not familiar with the German cases. I know Germany is a place where horizontal application of the law is more prevalent than it is in the US, but I don't want to speak more to the German cases than I'm able to.
So I'm glad you sort of ended on international human rights there, because we have a question from an anonymous attendee about that. The question is whether you can further elaborate on why Article 19 and international human rights law may be insufficient frameworks. And I'll just kind of pile on there and say, I think in some ways, as I read you would kind of like those frameworks better than the US doctrinal framework that tends to kind of hide the substance of the question. Whereas I think that the balancing approach brought by international human rights does tend to get to the substance and not sort of get caught ticking doctrinal boxes in the way that US courts can. But I do think you see some shortcomings of the international human rights framework for addressing the things we're talking about here. And it would be great if you could elaborate on this and tell me if I've misstated.
No, I think you're right. And what I would say is it's not so much that I think that international human rights law is necessarily an insufficient framework. I just think that it's not, it's underspecified so far. I think we could have a future. In fact, I think we will have a future in which it's much more specified in this space, but it's not yet. And I think that it's too quick to just analogize large YouTube and Meta and Twitter to the government putting someone in prison or something along those lines. And proportionality analysis should be attentive to the fact that those are very different sorts of things. It's not that you can't apply those frameworks. It's just that we don't know. We haven't really built out the principles yet to apply those frameworks. The Oversight Board does some of that work itself. But I think it's fair to say, we're relying on statements and norms that are not directly analogous to the context we're working within, right? So we're sort of striking out on our own, and I think a lot of this awaits further authoritative statements from, I won't be so bold as to call the Oversight Board an authoritative human rights body, right? There are others that should speak to these issues but haven't yet, and it makes the post World War II human rights regime has bigger fish to fry than like someone's thing getting taken down on Facebook, right? They're talking about people being tortured, and so we're just not there yet. I mean, I think there's a recognition that the kinds of harms that can occur at scale, at internet scale, can mirror those kinds of harms, but there's a lot of, and I think Daphne, I think you've used this word as well, a lot of translation that has to happen to get to the point where you can apply a text that is developed in the context of genocide and torture to platform behavior.
Yeah, I think it's interesting looking at the German Supreme Court case law, for example, which does do this more horizontal application of human rights and, comes out, sorry, it's the German, not the Constitutional Court, but the other one. I'm blanking on the name. Anyhow, it comes out doing something similar to what I think international human rights advocates like David Kay have done, which you talked about in the paper, of saying, let's take these private platforms and treat them more like governments, hold them more to the standards that a government might be held to, but in the German case law, not all the way there. We're just going to read more human rights obligations into the interpretation of this sort of contract of adhesion that is the TOS, and require more due process or require reinstatement in some cases and so forth, which is an interesting sort of parallel to, or flip side of what you're doing here, which is saying, well, what if we took the government and treated it more like a platform? You're sort of looking at bringing the constraints and challenges of operating a platform to the government instead of taking the constraints and challenges of governance or of human rights constraints and applying them to platforms. I'm curious how you see the relationship between those two projects, the kind of applying governmental standards to private bodies or more private body-like standards to public bodies, and do they just converge ultimately?
Well, I think that I think you're on to me in the sense that what I think if one takes a step back from what German constitutional law looks like, it's you don't start from, okay, here's a public entity, therefore the law applies, the Constitution or the basic law applies to this public entity in a certain way, and then here's a private entity and it doesn't apply. And maybe we'll think about if there's some reason, in a Marsh v. Alabama kind of way, there's some reason to think about the private entity the same. They're not putting things in categories in the same way, right? They start from we have a basic law. The basic law has a bunch of values. And every time there's a conflict that involves the government in any way, the values that infuse the basic law are going to have to infuse the conflict in some way. Sometimes that's more direct than other times. You got to pay a lot of attention to the institutional context. You've got to pay a lot of attention to the balance of harms, but you integrate public and private governance into a single regime, and I think that that's a very appealing way of thinking about this. I think it's hard to get to exactly that place from the U.S. And so instead of starting from the position of the U.S. should be more like U.S. constitutional law should be more like how the German Constitutional Court thinks about the basic law in Germany, which gets me nowhere. I think it's more fruitful to say, well, look, already within U.S. law, we have lots of interesting institutional variation if we peer closely enough and look a little bit beneath the formal statements of doctrine. We actually do differentiate in lots of interesting ways. And let's start from thinking about why we differentiate in lots of interesting ways and think about how platforms might look like that. And so in some ways, it's, if I'm a German at heart, this is a second best to thinking about an integrated legal regime.
Well, we're out of time, so I won't have time to ask you if you are a German at heart. That can remain a secret. So thank you so much for your time, for talking with this group. Thank you to everyone who submitted questions. I'm sorry we weren't able to get to all of them. I do want to remind people that this is an ongoing webinar series. Next week's webinar will feature the co-founder of Shiso, Erica Shimizu Banks, discussing inclusive approaches to content moderation. You can register online using the link in the chat. So Jamal, thank you so much for coming. And I look forward to seeing what more you produce along these lines.